So we're now in our third round. The third round is 6 minutes to the Conservatives, 6 to the Liberals, 6 to the NDP, 6 to the Liberals. Ms. Raitt.
Given the testimony that you provided for us today, Ms. Wilson-Raybould, I have to ask the question about whether or not you were approached by the Prime Minister, the Prime Minister's office, the Clerk of the Privy Council, and given any directions, directives, or suggestions on the conduct of the Mark Norman trial or any other trial that was within your bailiwick as the Attorney General.
I'm not at liberty due to confidences to discuss any matters beyond SNC and deferred prosecution agreements.
Thank you. And for clarity, can you tell us what you discussed with the Prime Minister at your meetings in Vancouver on February 11th?
I cannot.
And can you tell us why you've resigned from Cabinet?
I cannot.
And can you tell us what was discussed with the Cabinet on February 19th?
I cannot.
If the issues surrounding your ability to communicate these conversations to this committee were in fact resolved and you were able to be released from cabinet confidence or from privilege, would you be willing to return to this committee and give us testimony again?
I would be.
I'm wondering as well, Ms. Wilson-Raybould, that when the clerk was speaking with you in those communications, I know I've asked you already, but I want to just be crystal clear that when the clerk was speaking with you, he was speaking with the full weight and the authority of the Prime Minister, and it was your understanding that the Prime Minister was speaking through the clerk to you.
I can only go by what the clerk said to me in those conversations. In that conversation where he invoked the Prime Minister in terms of relaying messages from the Prime Minister.
Okay. And if I may clarify, in your statement, you have delineated these for us in terms of going through what the things that the clerk was saying on behalf of the Prime Minister. It's contained in your statement before us today.
That's correct.
Okay. A couple of times you have mentioned about your January 7 phone call with the Prime Minister about not going to be the Attorney General any longer. And you've indicated a couple of times that you didn't want to talk about what the contents of the conversation were. I respect that. I'm not going to ask you a third time. Can you tell us why? Under what authority are you saying that you don't want to disclose the conversation, just so that I can understand whether or not you were bound by something else so that we can perhaps take that roadblock out of the way to get your full testimony?
Well, I'm not going to provide legal advice to the committee, but I am going by the order in council and the waiver that was provided around SNC and deferred prosecution agreements, and any conversations around those topics when I was the Attorney General I am able to speak about.
Your Chief of Staff, her name is Jessica Prince, correct?
That's correct.
Was
former
she,
Chief of Staff.
I'm sorry, my apologies, correct. Your former chief, I understand fully the relationship between Chief of Staff and Minister, and it was pretty awesome that she decided to move with you to Veterans Affairs, just saying, it's very nice.
I thought it was totally awesome.
Yeah, very awesome. What I would like to know, though, is in her conversations with Ms. Telford and Mr. Butts, did she indicate to you, and I know it's hearsay, but you do have testimony talking about her text to you, did she have fear about whether or not she would still have a job as a Chief of Staff if she didn't convince you to review the decision on interfering with the trial that was ongoing?
I, of course, don't want to speak for Jessica on this, about the specific question on fear.
Yeah.
I can say that in my conversations with her and in my text messages, but particularly in my conversations with her after that, she was quite upset after the meeting. And I will say now that I have this opportunity, and I think some people are watching, to Jessica Prince, who was my Chief of Staff at the Department of Justice and came with me to Veterans Affairs. She is an extraordinary human being and an extraordinary lawyer.
Incredibly well-educated and very professional in everything she does. I would agree with you on that, and I think everyone will appreciate that you give kind thoughts to your Chief of Staff. That's always extremely nice. One last thing, if I may. can you remind us that, well, it's my understanding, and it was in the case when we served, that chiefs of staff are hired and fired essentially by the Prime Minister's office at the end of the day? It'd be difficult for you as a minister to retain a chief of staff that was not in favor with the Prime Minister's office. Is that true in your case?
I'm not going to comment on the interactions between my office and the Prime Minister's office.
Okay, thank you. Thank you.
Thank you very much, Ms. Raitt. Ms. Khaled.
Thank you, Chair, and thank you, Ms. Wilson-Raybould, for appearing today and sharing with us your viewpoints on this. I've always felt that you've been a very vocal advocate on issues that you genuinely believe in, without regard to other viewpoints. You've been vocal at Cabinet, you've been vocal to the Prime Minister, you've been vocal to Canadians. In fact, you've gone on the record at many public events and you've really expressed your viewpoints on issues that you genuinely believe in, such as the Indigenous file. And I just going through your testimony and your chain of events, I see that there hasn't been communication between you and the Prime Minister himself from September up until the time when he called you for the shuffle. Why is that? Why didn't you speak out to the Prime Minister when you've been so vocal on issues such as the Indigenous file, and you know that you have the access? Why did you not speak out to him when you had these concerns? And do you feel that you had an obligation to do so?
Well, I need to say a couple of things with respect to your question. I completely reject your characterization of that I do not have regard for other people's opinions. And you talked about the Cabinet table. And with respect, you would have no ability to know about discussions around the Cabinet table. I don't apologize for being vocal with my opinions. That doesn't mean to say that I don't value other people's opinions, because for the entirety of my professional career and how I was raised, in terms of consensus-based decision-making, it is incredibly important to take into account the views of other people. That's how we make good public policy in this country. You talk about Indigenous issues. I'm a proud Indigenous person from the west coast of British Columbia, and I will not apologize for being a strong advocate pursuing transformative change for Indigenous peoples in this country. I have worked in the Indigenous world as a politician for a significant amount of time and have a very in-depth understanding of the issues that Indigenous peoples face. That's not to say everybody agrees.
Ms. Wilson,
and I appreciate to hear other people's opinions. And to your question with respect to the Prime Minister, I believe I've covered that ground. I had a direct conversation with the Prime Minister, as I had direct conversations with the people in his office and the Clerk of the Privy Council.
Please excuse me, Ms. Wilson-Raybould. I was referring to your vocal advocacy as a sign of strength. You know, as a member of Parliament and your colleague, having worked with you, I acknowledge your effectiveness in advocating for the issues that you genuinely believe in, and we appreciate that. Thank you for your service. I do want to just understand here. You mentioned the political interference being cited as the Quebec election. And the Quebec election was over at the beginning of October. So if you can please help Canadians understand, from October to December, what was the context of the inappropriate pressure?
Sure. Yes, the Quebec election was something that was brought up on the September the 17th meeting. There were many other inappropriate conversations and attempts at political interference that occurred after that date. An example, which I've already talked about, was after I had made my decision as the Attorney General, which is entirely within my discretion to make. There were repeated attempts by people in the Prime Minister's office to get me to hire external legal counsel to evaluate my decision. There were further conversations about the election coming up, and if SNC were to move, this would be detrimental to the election. I further said that when we're talking about jobs and job losses, and of course I don't think there's anybody around this table that doesn't want to prevent job losses, that it was appropriate in the initial phases. But after I had made my decision as the Attorney General not to enter into or issue a directive, the successive and sustained comments around jobs became inappropriate because I had made my decision and everybody was fully aware that I had made my decision. I believe where it got even more heightened were what I described as the veiled threats that came towards the latter part of this time frame around December the 18th and December the 19th. There were many different occasions where the appropriateness line was crossed.
So just to clarify, thank you. Just to clarify, Ms. Wilson-Raybould, all right. So from after the Quebec election up until the end of December, as per what you've just said, are you stating, and I'm just seeking clarity here, are you saying that it was inappropriate because you had expressed that your mind had already been made on this issue?
My decision not to issue a directive had occurred prior to the September 17th meeting. The Quebec election, any partisan considerations before or after are entirely inappropriate, not relevant to me at the time wearing my judicial hat as the Attorney General in terms of considerations about whether or not I was going to exercise my discretion and issue a directive.
Thank you very much.
Thank you.
Mr. Rankin.
Thank you. Just a technical question at the front end, Ms. Wilson-Raybould. I wonder if you could provide the committee with a copy of all the text messages and emails that you referred to in your testimony.
I hear the question. I'll take it under advisement.
Thank you. You were, in referring to your conversation with Mr. Wernick, the top public servant in the country, the clerk of the Privy Council, in an answer to a question, you said something about waiting for the other shoe to drop. What did you mean by that?
Well, as I said before in questions, this was a very tense conversation. I had a high level of anxiety. This was the combination, or the culmination rather, of many phone calls and face-to-face meetings. What I meant by I was waiting for the other shoe to drop, at the end of the conversation, that's how we closed out our telephone call, was that I was under the understanding, based on what the clerk had told me, that he was going back to talk to the Prime Minister before he left, recognizing what he had also told me, that the Prime Minister was dug in, that he was firm, that it's not a good space to have an Attorney General at loggerheads with the Prime Minister. I had a heightened level of anxiety that I would be getting either a call from the Prime Minister the next day, which the clerk indicated might happen, and that there may be further direction or another outcome for me as the Minister of Justice and Attorney General.
In other words, consequences for you doing your job as an independent AG and saying you'd made your decision up, that was it. There could be consequences, is what you inferred from that conversation.
That is a fair assessment of how I interpreted the conversation.
Now, you've told us about a lot of officials in the Prime Minister's office, a senior clerk of the Privy Council. Do you not think that Canadians, because we're doing our job for Canadians to get to the bottom of this, that we would have a better understanding of the situation if we heard from the officials that you've referred to?
Well, I can't speak to whether or not you have a better understanding. I believe that it is important to hear from as many individuals that have direct connections or interactions in this case, which is why I don't know if pleased is the word, but I'm fine to be here and having this conversation because I know that it is important for me to put the facts before this committee for your consideration.
Thank you. You said wrote something very interesting in your remarks, and I'd like to read it to you. You said, the history of Crown Indigenous relations in this country includes a history of the rule of law not being respected. Did this, in your history, your experience that you've referred to, did this inform or strengthen your resistance to any potential perversion of the rule of law, that history to which you referred?
My lived experience is incredibly important for my background, my upbringing, how I think about the world. It's that lived experience, not only as a professional, but being rooted in my Kwakwaka'wakw culture and the values that I was taught by my father and mother and my grandmother that brought me to my role as the Minister of Justice and Attorney General of Canada. And I believed, and I still believe today, that it is incredibly important to have a diversity of perspectives and background, and to have a country, and we live in the greatest country in the world, that respects every individual with a recognition of the need for equality, of the need for justice, and in the case of Indigenous peoples, that we continue to work hard to create the space for Indigenous peoples to find their place and see themselves in the mirror of our Constitution.
Well, I understand that my time is almost at an end, and I just want to sincerely thank you. I want to thank you because you've presented a list of facts that I believe a reasonable person listening to this, and believing you as I do, would have to conclude demonstrate a sustained pattern of political pressure and interference with the independent role that you swore an oath to fulfill. And I cannot but think that we have more work to do as a result of your testimony. So I thank you sincerely, not just on my behalf, not just on our behalf, but on behalf of Canada, for your courage in being here and telling us what happened. Thank you.
Next we go to Mr. Bossino. Mr. Bossino.
Thank you very much, Mr. Chair and Ms. Wilson-Raybould. It's I really appreciate that you're here today. You and I have worked on a number of files together on a number of projects, and so I want to acknowledge your land acknowledgement as well. And if I were back in Treaty 6 territory, might say something like Mio Tatakwin Tatawa, which is Cree for guests, you're welcome, there's room here. So I appreciate what you've done. And that reconciliation and reconciliation with Indigenous peoples is all of our responsibility and the responsibility of all Canadians. I just want to ask a question because we all have our different ways of working, and I think it's known to people who've worked with you that you're a texter, and so I just want to know
I'm a what? Sorry?
You like texts. You communicate well by texting. And did you ever express any concerns to Jerry Butts in writing via text message when you were Attorney General? Were there any concerns expressed to him at all about this matter?
I would have to check, but I can't think of one off the top of my head.
Okay. Did you ever speak or write with Miss Katie Telford at all about the issue of SNC-Lavalin or other issues while you were AG?
Yes.
Did you ever speak about the issue of SNC-Lavalin, particularly with Miss Telford?
Not that I recall.
Thank you very much. Now, you see the Prime Minister regularly. You're in the House daily, there are cabinet meetings, there are committee meetings, cabinet room, caucus, other meetings, other events. You've talked about the September 17th meeting, and I have your document here, and I appreciate that you've provided a written document for us here. That meeting was with the clerk and the Prime Minister. My question for you is this: as Attorney General, and given all of the interactions that you detailed on that morning that played out over the course that you detailed with us this afternoon, everything that played out over September, October, November, and December, including the meeting with Ms. Prince, did you not have an obligation to raise these concerns with the Prime Minister, to call him or write him or stick up for your personnel, or indicate that you felt that inappropriate pressure was being applied?
So I did raise the inappropriateness of the conversations. I raised it with many individuals within the Prime Minister's office. I raised it with the Prime Minister on January the 7th. Let me say this. And again, I am confident and know my role as the Attorney General, and I know and understand that I am the final decision maker on this. Mm-hmm. When faced with sustained pressure from attempts at interference from September the 17th up to and including December the 19th by the Prime Minister's office, by the Clerk of the Privy Council, invoking the Prime Minister's name, I had concerns. Well, I had beyond concerns. Why would I go to the Prime Minister to raise these concerns when I knew for certain that the DPA with SNC would not occur because I am the final decision maker? And
I'll get
other
back to that issue of final
in the
decision
Prime
making.
Minister's office that were putting pressure on me to change that, included by virtue of the conversation with the clerk, the Prime Minister.
So I appreciate that. January 14th, you accepted a new appointment to Cabinet as the Minister of Veterans. And you know what it's like in caucus. There are people run, they want to be MPs, and people want to serve around the big table. And that's part of being in this role. And it's a great honor to serve as a minister in any portfolio. And I can't imagine the great honor that it would be to serve the people who've served this country and who now live after having served. And so after you reaffirmed, on that day, accepting that position, you reaffirmed your confidence in the government. Is that the case?
I was incredibly honored to be the Minister of Veterans Affairs. It was a very different position from the one I had, but I embraced it, and I had a lot of considerations to make on a personal level over the time of Christmas and into the new year, and I'm getting to answer your question. I had serious concerns, as I said, that if I was no longer the Attorney General, that there would be a deferred prosecution agreement entered into and that it would be posted in the Gazette. As I said, I would have resigned from Cabinet at that time. I decided, a very conscious decision, to take on the role that the Prime Minister offered me, and yes, it is an incredible honor. I don't want anybody to misconstrue that. I decided that I would take the Prime Minister at his word. I trusted him. I had confidence in him. And so I decided to continue on around the Cabinet table with the concerns that I had around SNC because I took the Prime Minister at his word.
Thank you. So that oath that you took today, that oath that you took on January 14th, reaffirmed your confidence in the government. Do you have confidence in the Prime Minister today?
I'll say this, and I'm not going to get into any conversations about why I resigned. Other than to say this. I resigned from Cabinet because I did not have confidence to sit around the table, the Cabinet table. That's why I resigned.
My question wouldn't be why you did resign. My question would be, why didn't you resign before?
Folks, we are now, we've completed 3 rounds. Do we have people that wish to go to a fourth round? Yes. So we will go to a fourth round. Would the witness like a break, a bathroom break?
I
Or
don't even know what time it is. So
I can tell you it's 5:53. Would you like a break, Ms. Wilson?
no, I'm good.
You're good? Okay. So the fourth round, just so that I have it correct, starts with 6 minutes to the Liberals, 6 to the Conservatives, 6 to the Liberals, 5 to the Conservatives, 3 to the NDP. So, Mr. Boissonneau, are you continuing? Mr. Boissonneau.
Mr. Chair? I would be happy to. So, okay, it's going to go red. Okay. So, Ms. Wilson-Raybould, you know that I come at these things from a non-legal perspective. I was in business before this, and I'm learning what it's like to be on the Justice Committee. And so it often leads me to seek to understand certain legal principles. And so we've heard here today, and in testimony from other witnesses, including Wendy Berman, Kenneth Jull, and the Clerk of the Privy Council, that the AG has a role to play in remediation agreements. And you mentioned in your document here the concept of prosecutorial discretion. And one of the duties of a prosecutor is to just determine whether to prosecute or not, correct? Okay. So from the Public Prosecution Service of Canada handbook, which is available on the Justice Department website if anybody wants to look at it, it says very clearly, when deciding whether to initiate and conduct a prosecution, counsel must consider two issues. Is there a reasonable prospect of conviction based on evidence that is likely to be available at the trial? And if there is, two, would a prosecution best serve the public interest? So with this in mind, would you agree that the two questions for a prosecutor are reasonable prospect of conviction and public interest?
Those are definitely questions that the prosecutors take into account.
Okay, so then to go back to the handbook, on the basis of the available material, Crown Counsel must continually assess at each stage of the process whether the prosecution is in the public interest. So I look at this from outside of the legal community, and with the need to continually assess in mind, wouldn't it be fair to say that a decision to continue with the prosecution is never final and is subject to reevaluation in the light of the reasonable prospect of conviction in the public interest? So the AG should have an open mind to new information coming in all the time, and really the decision is never final because it's still active. Like, you have to continually assess new facts and new information. Is that not the case?
Are we talking broadly, or are we talking with specifically to SNC and the DPA?
Well, broadly first, and then I'll get to SNC-Lavalin.
Well, I recognize that it is entirely within the prosecutor's ability and discretion to continue to evaluate prosecutions. I was a prosecutor proudly for almost 4 years.
Okay, thank you very much. So then I also saw that in the Justice Department material issued last year in September, that a goal of remediation agreements, one of the goals is to reduce harm that a criminal conviction of an organization could have for employees, shareholders, and other third parties who did not take part in the offense. So if we then look at the Criminal Code, Section 715.31 sub F, it says that a remediation agreement is to, quote, reduce the negative consequences of the wrongdoing for persons, employees, customers, pensioners, and others who did not engage in the wrongdoing, while holding responsible those individuals who did engage in that wrongdoing. So I think it's fair to say that with the extent of the company, its history, the fact that it employs almost 9,000 people in the country, 52,000 globally, there's a local impact on the communities, home to many innocent pensioners, suppliers, and customers. In your consultation, you said you did a due diligence. How did you take into account the public interest and the impact on the thousands of innocent employers, pensioners, and suppliers if a DPA would not be entertained?
So, Mr. Chair, I believe we're treading on dangerous ground here. I fundamentally uphold my responsibility as a member of Parliament in the sub judice rule, and do not feel it's appropriate, one, for me to answer questions with respect to remediation agreements, the criminal code, or in relation to SNC and DPAs. I believe that's the nature of the question, and I think that members of this committee should tread lightly on interfering with active cases before the court.
Mr. Chair, I appreciate the warning, but Ms. Wilson-Raybould, my question is about the public interest. It's not about a particular matter, and the clerk and perhaps the chair can clarify the sub judice matter. But how could an AG make a decision, and in your words, have a final decision without taking this information into account? It's clearly in the public interest.
Again, and I would appreciate some comments from the chair on this, but I will say, and it's entirely appropriate, and I said it in my testimony, as the Attorney General, all Attorney Generals get Section 13 notices from the Director of Public Prosecutions. The contents of that notice are between the Director of Public Prosecutions and the Attorney General of Canada. I will not go into talking about any of the situations, scenarios, conversations about the national interest with respect to SNC-Lavalin, and I would appreciate hearing from the chair on this.
Thank you very much. So what I would suggest is to keep it to general or a hypothetical of a situation and not to deal with the SNC question specifically as to her decisions on SNC. That's my suggestion. Members, of course, have the absolute right to ask questions here. The witness has the absolute right to answer or not answer based on her own inclinations. And then the committee, should they decide that they want to ask her to answer regardless, has that power. So my request is to try to keep it general or hypothetical to the extent you can.
I appreciate that. Let me ask this question then. What legal doctrine or what legal principles led you to the conclusion that the conversations that you were having with members of the PMO and other colleagues had, in your words, constituted inappropriate pressure? On what basis did you make that assertion? What legal basis? Because we heard from legal scholars that the bar is really high and the bar is very close to direction, and having a conversation, a robust conversation about the public interest or about saving 9,000 jobs or 52,000 jobs is completely legitimate and appropriate conversation. So what's the legal basis on which, what's the doctrine you used to say that your decision was final and you were done taking in new information?
Well, I appreciate the question, and I can reiterate what I've said earlier. I recognize that when I was the Attorney General, and certainly Attorney Generals before me and after, it's entirely appropriate to consider discussions around the public interest. And I had discussions with colleagues with respect to SNC and deferred prosecution agreements about the potential losses of jobs, the potential of SNC moving, but having taken into account everything that I did when I was the Attorney General, including having conversations with my department, my Minister's Office staff, and doing my own due diligence, I had made my decision that I was not going to exercise my discretion and issue a directive, either a directive under Section 10 or under Section 15 and take over the prosecution, because I believed it was inappropriate to do so, recognizing that the Director of Public Prosecutions had made their decision.
Thank you very much. We go to Ms. Raitt.
Thank you. Just back on the directives for a second. Ms. Wilson-Raybould, my understanding from taking a look at reports, these directives are very rare in practice. I mean, I think there have been 3 substantive ones in the past 13 years, 2 from yourself, one on HIV positive prosecutions, one on, I believe, on Indigenous prosecutions as well. I think that was recent, but it didn't make it onto the list. And one from our government on terrorism. Other than that, my recollection is that there really aren't any other directives of a significant heft on policy.
So if I may,
yes, please.
Yes, there was a directive around, I can't remember the exact thing, around terrorism.
Yeah.
There was a directive that I issued and was pleased to work with the member, Mr. Boissonneau, on the HIV directive, which I had to follow the process that's outlined.
Yes.
It was a general directive, as the terrorism one was, to provide guidelines to the public prosecutor. In issuing that directive, I had to follow procedures, including putting the directive into the Gazette. Prior to that, I had conversations with the Director of Public Prosecutions, Kathleen Roussel, about the HIV directive, as is entirely appropriate. So that directive came in early December. The other directive, I believe you're referring to the Indigenous Litigation Directive. Yeah. This was not something that I issued through the gazetting process. This was a directive, an internal directive that I'm really happy to have issued internally within the Department of Justice in terms of Indigenous litigation. This did not go through the gazetting process because it was a directive to the litigators in the Department of Justice.
That helps me very much. Now I know why it's on the list, so that's good. But rare. These things are rare. They're very unique and special.
They are very rare. That's not to say that it's not a tool that an Attorney General can utilize. General directives, the two that we've spoken about, have been issued, but there has never been a specific directive issued on a particular case before the courts, nor has there ever been utilized under Section 15 an Attorney General taking over the prosecution. Yeah. It is and would be a first if that were to happen.
Extraordinary. Thank you. I have a question about some testimony that the Clerk of the Privy Council gave to this committee. I'm a little troubled by an inconsistency, I'll be honest, and I just wanted to get your take on this. And it's not that difficult. It's not he said, she said this time. The Clerk of the Committee told us that he learned that a deferred prosecution agreement was not going to be offered to SNC-Lavalin sometime after September 17th, sometime in the fall, he said, and he learned about it through a National News Watch story. Now, your testimony here tells me that he was sitting in the room for the meeting where the Prime Minister brought up the deferred prosecution agreement. Is that your recollection, that he was in the room September 17th and would have known that SNC-Lavalin had been told by that point that they were not getting a deferred prosecution agreement because he was part of the conversation around that topic?
The Clerk of the Privy Council would have known on the September 17th meeting because I specifically mentioned it to both he and the Prime Minister, going into detail about the Section 13 notice that I received, and again, I was very clear that I had already made my decision around the deferred prosecution agreement and not intervening.
Thank you. And this committee is here to study a number of issues and to probe the conversations that you had. Committees by nature tend to send reports to Parliament as a result of their study. I'm wondering if you would have any recommendations for this committee for their report in order to help into the future. And I'm not getting into any specifics, just having gone through what you've gone through, anything that you think we should be reporting into Parliament, that would be helpful to our colleagues.
Well, now that you mention it, I think this is a very serious question, and I'm going to try and give you, I'm not going to try, I'm going to give you a serious answer, and I've thought about this a lot. I hope that the committee takes into your previous question as much information and evidence as you can. I appreciate the study on remediation agreements, talking about a relatively old doctrine, the Shawcross Doctrine. I would think it would be a very useful study for this committee to look at the role of the Minister of Justice and the Attorney General of Canada and whether or not those two roles should be bifurcated. I believe, and I have believed this for some time, even before I became the Attorney General, that our country would benefit from a detailed study and consideration around having the Attorney General not sit around the cabinet table like they have in the United Kingdom.
Okay, thank you. Is that it?
You have 10 seconds.
That would be it. You can take a breath. Have a drink of water.
Thank you very much.
Thank
Ms.
you.
O'Connell.
Thank you, Mr. Chair. Thank you again. I want to speak a little bit about the Privy Council Clerk, Mr. Wernick, his testimony. And he spoke about the Shawcross issue. And in some of his testimony, I'm paraphrasing, but I'm sure we could pull up if you want the exact text. But he talked about Shawcross in the context of there's always conversations. I think you even acknowledge that there are legitimate conversations to be had for consideration. And Mr. Wernick pointed out, and part of Shawcross, which I think is relevant here, and I'm going to quote, in order so to inform himself, he, in this day and age, it's also she, may, although I do not think he/she is obligated to consult with any of his colleagues in the government, and indeed, as Lord Simon once said, he would in some cases be a fool if he did not, end quote. So that's referring to Shawcross and what Mr. Wernick said. In your testimony today, you mentioned that on September 16th, when there was meetings with your chief of staff or a phone call with Mr. Bouchard and Marquez, the comments were, and you put it in quotes, we think we should get some outside advice on this. Then on, again, referring to your testimony, October 18th, it was also Mr. Bouchard who spoke to your chief of staff and asked if we could get the option of seeking external legal opinion on the DPP's decision not to extend an invitation. Referring back to September 16th, because I heard your testimony that you said you had made up your mind on the issue and that you were not going to intervene. However, in that September 16th commentary that you provided, it was expressed that they said they understood the individual Crown prosecutor wants to negotiate an agreement, but the director does not. So that somewhat indicates to me that even within the prosecution side, there was debate. There was debate on whether or not this was appropriate. And then, so is it unreasonable then, if there's even still debate within the Crown Prosecutor's office or whomever they are referring to there, is it unreasonable then to bring out other advice, which was asked for on September 16th as well as October 18th, to see what legal options there were, since there was clearly within, whether it was with yourself, your office, the Prime Minister's office, within the prosecution, there seemed to be disagreements or differences of opinions, let's put it that way. Why would it have been unreasonable, and then referring back to the Wernick testimony and Shawcross in saying that you would want to consult as much as possible on these types of matters? So if there were still some differences of opinions, what would the objection be to bringing in another opinion, an outside legal opinion?
Well, I think I'm fine with it. We're going over very similar ground here. But I had made my decision as the Attorney General. I did not need external legal counsel. I did not need people in the Prime Minister's office continue to suggest that I needed external legal counsel. That's inappropriate. But I will say, with respect to the conversations that you mentioned with Mathieu Bouchard and his remarks about an individual prosecutor as being different from that of the Director of Public Prosecutions, I can't help but wonder why he would bring that up, how he would know that, how he garnered that information. It is entirely inappropriate for any member of the Prime Minister's office, and it would be entirely inappropriate for any member of my staff or within my department to reflect those conversations, because I would have serious concerns, and I did at the time and still do, concerns about how that information was acquired and from whom.
Thank you. So if you felt that information was so inappropriate September 16th, did you consider resigning? Like, if it's moving forward and they continue, did you not consider resigning then?
I did not consider resigning then. I was, in my opinion, doing my job as the Attorney General. I was protecting a fundamental constitutional principle of prosecutorial independence and the independence of our judiciary. That's my job. That was my job, rather, as the Attorney General. And as long as I was the Attorney General, I was going to ensure that the independence of the Director of Public Prosecutions in the exercise of their discretion was not interfered with.
Do you still have confidence in the Prime Minister today?
I'm not sure how that question is relevant.
Okay.
Thank you very much. We will now go to Monsieur Paulus. But Monsieur Paulus, Mr. Cooper has asked me to give him the last 3 minutes of this 5 minutes, so I'm going to tell you at 2 that we're going to Mr. Cooper.
Oui, merci, Monsieur le Président.
Thank you, Mr. Chairman. Ms. Wilson-Raybould, on December 19th, when you received the call from the Clerk of the Privy Council, Mr. Vernick, the highest public servant in the land, he said, and I quote, he wanted to give you context on this issue. How did you feel about that?
Well, I believe that the clerk also made similar comments when he was before the Justice Committee. As the Attorney General at that point, after 4 months of these conversations, well, actually not even after 4 months, after making my decision, I was entirely comfortable that I had the appropriate context in which to make my decision. I did not, as the Attorney General, live in a vacuum. I have the ability to engage in, read papers, have discussions about the reality of SNC and deferred prosecution agreements. Of course, I was sitting around the cabinet table. I didn't need any context. I certainly didn't need context about the exact same context that I was provided for or in 4 months previous to that.
Est-ce que vous avez considéré que c'était une forme?
Did you feel that this was an interference in justice? An obstruction of justice?
It wasn't an interference because I never let it happen. There was, and let's be clear about that, there was a concerted and sustained effort to attempt to politically interfere with my role as the Attorney General. As the Attorney General, I did not let that happen.
Merci, Madame.
Thank you, Madam.
Much, Ms. Wilson-Raybould, and it's a sad day. And I thank you very much for your candor here at committee. Going to the Clerk of Privy Council, the call that you had on December 19th, was it typical to receive a call with the Clerk of Privy Council? Did that happen often?
The answer is no. But I can't, and I could endeavor to think further about this. It's not that I haven't had conversations with the Clerk of the Privy Council one-on-one. I did have a conversation with him on September the 19th, one-on-one in my office. I have known the clerk for many years, and throughout the course of my being a minister, we have had the opportunity to have conversations, but a direct conversation or a direct meeting is something that wasn't very regular.
Right. Well, thank you for that. And in your opening statement, you characterized the meeting by stating that, quote, I was having thoughts of the Saturday night massacre. Can you elaborate on that?
Well, I'll give a bit of a Wikipedia version of the Saturday Night Massacre, and perhaps people know what that is. So the Saturday Night Massacre is something that's commonly referenced in and around former President Richard Nixon when he, in the early 70s asked his then Attorney General to dispense of a special prosecutor. The Attorney General said no and resigned. The then president, then asked his deputy attorney general to do the same thing, and that person resigned. So it's commonly referred to as the Saturday Night Massacre. Anybody can look it up. So I, having said that to the clerk, obviously was having thoughts about what was happening, the potential for direct direction. Is that right? The potential for direction coming to me from the Prime Minister, and my having to consider resigning.
So it was certainly a little more than...
Last question.
It was, well, I was just going to make a comment. It was a little more than the clerk just checking in with you, as he characterized it.
The clerk was checking in with me on SNC and deferred prosecution agreements.
Thank you very much. We now go to the NDP 3 minutes. Mr. Angus, are you going to do this? Mr. Angus.
Thank you, Mr. Chair. Thank you, Ms. Wilson-Raybould. And I'm actually very honored to be sitting at this table today because what I feel we've witnessed is not politics. We've witnessed a lesson in integrity. I think that the testimony that you gave today will be studied in schools for decades to come, and Canada will be a better place for it. Because the greatest thing we can ask of any public official is to speak truth to power. And I really noticed that in your resignation statement. So I have a very short period of questions. I just want to make sure I understand the frame correct, because it seems what we heard today is a sustained and constant attempt by very powerful actors in the Prime Minister's office who are obligated to uphold justice and the rule of law, yet attempted to interfere with the practice of the rule of law. Would that be a correct assumption from the testimony that you've provided to us?
Thanks for the comments and the question. Again, I know that there was a consistent and sustained effort to attempt to politically interfere with my role as the Attorney General. And I really want to say this, and I'll be brief. I do not want members of this committee or Canadians to think that the integrity of our institutions has somehow evaporated. The integrity of our justice system, the integrity of the Director of Public Prosecutions and prosecutors is intact. So I don't want to create fear that that's not the case. It is incumbent upon all of us to uphold our institutions and to uphold the rule of law. And that's why I'm here.
Well, I thank you for that, because I was really shocked when I read the testimony that you provided recording for Mr. Wernick, the Clerk of the Privy Council, who is obligated to be the nonpartisan voice of the civil service. And he said, I think that would be the Prime Minister, is going to find a way to get this done one way or another. He's in that kind of mood. I want you to be aware of that. And then you referenced the Richard Nixon firing of the special prosecutor as a side issue. But would you take from that, he's in that kind of mood, and I want you to be aware of that you were being given a direct threat regarding the Prime Minister?
I believe that there were 3 occasions in that conversation where there was a veiled threat.
Okay, thank you. I know I only have a few seconds left, but I've heard my colleagues in the Liberals today say, why didn't you resign? Why didn't you raise this as though it was your responsibility? And then why did you not get outside advice to help you change your mind? I'm really pleased that you say that these were attempts to obstruct and to interfere with justice, but the justice system is intact. My question to you is, are you worried that the Prime Minister's office was seeing the role of the Justice Minister as a figurehead that could be moved around, could be changed or interfered with based on the partisan or political needs of the moment?
I'm not going to speculate on considerations in the Prime Minister's office or opinions.
Fair enough. I just want to say, Mr. Chair, I want to move a motion.
Mr. Angus,
that
you've
the
exhausted
committee
your time.
calls on the
Mr.
Prime
Angus, you've
Minister.
exhausted your time. You don't have the
I'm
floor.
moving a motion.
I think I had passed on. What?
Sorry, I'm moving a motion, Chair.
I had not. Okay, so I had at that point already said, Mr. Angus, you're out of
But
time.
my microphone was still on, and I said I was moving a motion.
I didn't hear you say you were going to move a motion. I heard you. I said
yes.
you were out of time. I was going to move to the committee to ask to the committee if they wish to go on to another round of questions. I will come back to your motion after we establish whether we want another round of questions. Folks, do you guys want another round of questions? Yes? Okay, so there's a desire for another round of questions. Mr. Angus, what is your motion?
I don't know if we need another round of questions. No, I think we're done. We're done. Yeah.
Well, so also he's not the member of the committee. A couple of things, you know, a couple of things. So just for clarity, though, Mr. Angus, you're not actually a member of the committee. Mr. Rankin is here, so you can't move a motion. Let's go with that. Number two, the issues with respect to moving forward on another round. If there's a disagreement with that, then we would have, I guess, to have a motion and a vote. If we're not consensually moving to another round, do I have a motion to move to another round of questions, Mr. Boissonneau? Is there a debate on that? Is there any debate on that? All those in favor of moving to another round? Okay, so we're agreed to move to another round. Now, the next round. First of all, Ms. Wilson-Raybould, you've been sitting here for quite a while. Would you like a break?
I'm okay.
You're okay.
But,
If you're okay,
if we get to
I
9
applaud
o'clock,
you.
I probably will have a different answer.
I applaud. Please let me know if there is at any point you feel you need a break. So the next round, which would be going back to the way the first round goes, it's 6 minutes to the Conservatives, 6 to the Liberals, 6 to the NDP, 6 to the Liberals. Ms. Raitt? Ms. Raitt.